Hello everyone, I'm Coach Albert Platt, California Baptist University graduate student, Department of Kinesiology. Today I'm going to go over my critical assignment, Legal Issues in Kinesiology presentation, and let's get started. Now, the facility background that I'm going to be working on is a community college coach and instructor. Now, there's certain aspects, environmental setting, working with collegiate athletes, working with a well-structured facility such as a weight room, personal training, gymnasium, and athletic fields. Being a community college coach and instructor, you're going to be instructing various courses, techniques, and variety of methods to student athletes on physical education standards and demands for the individual need. And also you're going to be doing coaching competition preparation for the sport game and for development, improving, enhancement for optimal performance, from, in my case, in the sport of football. Now, in the facility, we're going to be executing individualized drills, exercises to suit each specific need, and to achieve success by placing a high standard on emphasizing to meet the team individual needs for each athletic team or athlete through various training procedures and coaching practices. Such examples given as like athletes in speed, acceleration, explosion. Now, being a community college coach and instructor, there's certain legal aspects you have to be fully aware of working within the facilities. The past legal issues I have here, for example, is the MOG versus Tuscaloosa College Incorporated. We're just going to say MOG, because I don't know how to pronounce it, MOG versus Orleans Parish School Board, and Lorenzo versus Monroe Community College. Let's get in detail on those past legal issues. And the Morrow case versus Tuscaloosa College. The facts of this case involve an action of a student, was Donna DeMorrow, against a private college, Tuscaloosa College, for personal injury developed while she was in a physical education class. The plaintiff, the beginner is a beginner in golf and a freshman in college, was hit by a golf ball driven by a senior student who was also registered in the classroom or in the physical education course, and who was taking the class as an elected teaching assistant. So the teaching assistant is running the class. Then once she put suit, the jury returned a verdict for the plaintiff, which was approved by the trial judge. The Court of Appeals ended up split decision, reversed, and dismissed the action due to there was no evidence of cognitive negligence. The court deemed while the accident was an unfortunate occurrence, the matter of the law, which the education ministry could not be held responsible for action. So we have to be careful when we're teaching in the courses, or if you're an intern or like a teacher assistant. There's certain guidelines and certain aspects you have to be fully aware of. Now, in the case of MOG versus Orleans Parish School Board, the plaintiffs, Joy MOG, and her husband, Dr. William MOG, filed a suit against the defendants, Orleans Parish School Board. Robert E. O'Neill is the head coach at Benjamin Franklin Senior High School, and his assistant coach are Sam Mondello, and also the principal of the school, Estelle Barkenmeyer. The superintendent of Orleans Parish School Board is Dr. J. Caldoche. The supervisor of health is Jack Pisano, a safety and physical education division instructor of the parish school system. The plaintiff sued to recover judgment in favor of Mrs. Joy in the amount of $55,000, in the favor of Dr. William Mogg in the amount of $56,000. As the suit is together with the judgment against the Continental Casualty Company of a penalty of 12% of total plaintiff charges. The plaintiffs have declared that the damage experienced by the death of their son Robert resulted in negligence of the defendants to fail to perform the duty of prime minister's. See, what happened here is the student was dehydration. He took a head to the blow, was dehydrated. They took the student athlete into the cafeteria. They tried to revive him. They did bad protocol in trying to help the football player, come back from what was going on. Fortunately, there was a death of their son, and there was a lawsuit there. The third and last, legal issue that could cause in the facilities is Lorenzo versus Monroe Community College. The plaintiff, Annette Lorenzo, was a college student at Monroe Community College in the fall of 1976. The plaintiff enrolled in gymnastics course taught by the defendant, Sylvia Yeager. And on October 26th, the school year of 1976, Lorenzo was in a class when she fell by attempting to do a jumping exercise. Well, Uyghur was the only teacher of the class of the 30 students, and during the time of injury, she was in another part of the gymnasium, did not witness the accident. Before the defendant left or the other part of the gym, she gave preliminary instruction to the entire class on the use of the certain technique and the equipment being used. However, she had never demonstrated the proper techniques to the class or to the plaintiff on the jumping exercise, the fundamentals of it. And so the defendant asked the plaintiff if whether she had any gymnastic experience or has ever demonstrated any experience in jumping exercise. Well, Yeager was well aware of the plaintiff was not athletic, was a bit overweight, and from the defendant's experience, a person with such intangible generally needs more instruction, coaching than other participants. A little more hands-on to really explain the technique and fundamentals. The plaintiff was not required nor directed to do this exercise as part of her class participation and wasn't present to assist and counsel her on proper technique. So the plaintiff decided to attempt the jump on her own. Well, you know what happened. She ended up getting hurt. She ended up doing a suit. And, you know, this court summary judgment and drastic remedy should not be granted, and it was dismissed because the plaintiff claimed to sue with a defendant called instructor provided adequate supervision. Thus, in the absence of evidence, the plaintiff's injury was exclusive result of her own disregard in the instructor's rules and lessons plan. So she did it on her own. So as a collegiate coach or instructor, you just have to be well aware of what's going on in your surroundings. Just kind of monitor, just to avoid those legal issues. Now we're going to talk about risk management, being a community college coach and instructor. There's a lot of little facets with risk management that could cause many legalities in this profession. So in the professional career path, there's a lot of potential risks that could arise if not aware of certain aspects that could inspire in the facilities and practice fields. There are specific procedures one must take in order to prevent and manage each of these risks so no harm can come to the facility, client, or instructor. Now, as a community college football coach and instructor, it is imperative and very important to know such risk management procedures just to avoid any potential risk of injuries or any prevention of within the confines of the career. Now, if you're on the field or something happens or you're in the weight room, you got to know these. You have to know these potential risks of injury, and you have to know how to prevent from having these type of injuries or these risks. Now, in many sports activities, there will always be some sort of involved situations that may be potential level of risk. Source of harm to people, the likelihood of hazard, must have knowledge and risk assessments, which involves the keen identification of potential risk within the sport or career of your choice. Now, while this method of identifying and implementing measures of risk can be used to control the level of exposure to some consequences. So you must know the level of preventative injury and can be achieved through issues of risk identification and application of appropriate risk perceptions, risk communication, and risk management measures. So you always have to be, just like I explained earlier in the facility background, know what's going on in the facility. Same applies to here. You have to really know and be fully aware of measures in the facility, measures with the client, and you as an instructor, you just have to be well prepared so you don't get in a situation where it's going to cause you to, be in a legal issue. Now, the past legal issues are Mann versus Palmerton River School District, Los Eleno, John Coleman, and Reeves, Benson versus Owen. So, Mann versus the plaintiff, Mann was a student, participating in school football program. Sheldon's parents, the plaintiffs, filed action versus the district, and on the Coach Walkiwiak, I think that's how you pronounce it, who was also assistant coach of the football team. While he was promoted and in his preparation to be head coach from an assistant coach, he did receive some sort of concussion protocol safety training. However, he was in a practice, student gets hurt, he was unaware of the signs and symptoms of the concussion, and Sheldon took a brutal hit, which he did cease practice. However, he suffered traumatic brain injury. So the fellow players also testified against the coach that Sheldon appeared to be dazed and confused, disoriented, from a prior injury, prior hit during the day of practice. So the plaintiff's claim against the action against the school district and the coach for violating Sheldon's constitutional rights and causing his traumatic brain injuries. But according to the plaintiff's claim, the Sheldon's rights were violated as a result, as the coach does, exercise of authority, telling him to continue participating in a football practice after sustaining a hit and exhibiting signs of concussion. So the claim, Sheldon's rights were violated. The district's practice of failing medical clear students. So that was a legality that was forced, and obviously, the parents won because of the injury of their son. So as any coach, you have to be well aware of any type of injuries and avoid those risks, so you don't get into situations and problems. Now, to alleviate this, specific way to mitigate, you got for the potential risk is to prevent such litigations. He should have ended the practice as soon as possible, call for immediate assistance. If it was pretty serious injury, the player showed signs that he or she was dying within the practice of harm or dying because of the blow to the head. Could have like a CMP or crisis management plan would have been useful for preventing or any legalities of coach. Developing a CMP is similar to an EMP, emergency action plan. However, it's specific to emergencies that are greater in scope and are more damage to the player. So if the coach would have created the CMP, would have covered a wide range of potential risk, and it would have been avoided such harm to the student athlete. The CMP is good to initiate a plan that is based on operational capabilities and having existing resources that will alleviate the reputation of the coach, organization, if it's properly planned, and it would have, offset this unfortunate injury. The next case is Losileno and John versus John Coleman Catholic School. The plaintiff is Richard Losileno was involved in injury for not having proper equipment that was provided by the defendant. The plaintiff, a senior at the high school, was participating in a once-in-a-year intramural football game involving physical contact. The game was officiated by 2 instructors. That's a big issue there because they're not certified from the school, and no protective equipment was provided to the coach or the high school. So the plaintiff sustained a dislocated shoulder during the game while attempting to tackle another player. The plaintiff filed an action claiming the coaches failed to supervise and provide proper equipment. Now, maintaining and providing proper equipment will reduce sport injuries as well as having proper instruction supervision. There was actually statistics on it. But to alleviate the situation, by following such protocols such as inspecting the equipment, giving equipment out, instruct proper usage, teaching and knowledge, and knowing relevant documentation of safety and warnings, or maybe being properly certified to fit the athlete and showing proper teaching how to wear the appropriate equipment, the activity will reduce injury and prevent injury from happening. So working in this facility, in the facilities, is you have to, alleviate any potential risk involving as a coach or instructor by implementing proper equipment. And the last one is Reeves versus Benison versus Gagetown Area Schools. The defendants were Arnold Benison and alleging violation of fair protective civil rights. The plaintiff alleges the defendant was the acting agent for the school district. So the plaintiff was seated in one of the front of the bus. What would happen was the plaintiff was sitting in one of the bus. There was a fight broke out. He got injured. The coach wasn't paying attention, just to cut it short. And the defendant was negligent, and it kind of caused the plaintiff to show a particular course of action because he was hurt. So to avoid this situation too is supervision. You have to have supervision as an instructor and a collegiate coach, because the supervision addresses issues during practices, games, ensuring safety, and will teaching the sport progressively by certain strategies, such as like arm strike supervision when circumstances dictate harm, activities in the facilities in which physical contact is possible. There are many steps that should be taken to minimize potential risks, so you wouldn't mismatches. Certain facilities, have liability issues with transportation. Just have to have supervision. Just make sure your client or student does not get injured or any harm comes to them. We're going to go over employment laws now. Working as a collegiate coach and instructor, there's some employment laws that must be known, and you have to know. You know, in the renowned realm of collegiate employment, there are many aspects of problems that arise in hiring process of employment by the administration. You know, such as age, gender, sexual orientation, discrimination, religion, and adequate knowledge of employment laws. I mean, you have to really know your laws. Now, every state's different, but they have certain employment laws. I mean, employment law contains a wide spectrum of concerns that can develop in a specific environment of work, from relationships with people or clientele or student with their professional career. Now, lawsuits are stemmed from an employee that is set aside for an upgrade in pay raise, a promotion, or fired. An applicant employee is subject to discrimination. An applicant that is highly qualified is not hired due to interesting reasons unknown, and an employee is actually harassed while on the job, or if an employee has injured themselves or has injured others while in the workplace, is being, you know, not fully aware of what's going on in the surroundings. Now, past legal issues with this is like Moore versus University of Notre Dame, Ivy versus Ivy Tech Community College, and Purdue versus City University of New York. The Moore versus University of Notre Dame case, the plaintiff was a former assistant football coach. He brought claims of defamation, alleging discrimination under common law because he was older. So he's fighting he was fired and brought in action because the head coach University of Notre Dame for violation of the ADEA, which is the Age Discrimination in Employment Act. So the plaintiff brought a common law defamation action versus defendants and a corporate publisher for professional and magazine for false statements that the plaintiff could not only coach 1 or 2 more years due to his age. You know, age should not, especially like over 40. I mean, that is very important. Age over 40 is like, that's, you know, really have to be really open and not cause any situations, because you could be in an issue. Now, like, you could avoid this issue, like University of Notre Dame could avoid the issue if to avoid and permit this specific issue is the employee must abide by the rules of the ADEA. The ADEA prohibits employment discrimination on the basis of age for individuals for at least 40 years old. This law applies to organizations, institutions, or businesses with 20 or more employees. Now, if a qualified applicant or employee is 4 years old, you must take certain implicated factors. There must be no certain implication of factors of discrimination occurring in the hiring process. You would be or promotion or termination, because you could be in a little bit of a problem because the claim could be brought up on you or someone who believes they're being mistreated or doing next. Ivy versus Ivy Tech Community College. This case was very interesting because this instructor wasn't. She taught there. She began teaching there part-time as an adjunct professor, and then she filed a charge with the Equal Employment Opportunity Commission, the EEOC, claiming that she had not been discriminated. She had been discriminated against on the basis of sexual orientation. So the plaintiff stated that she had been blocked from full-time employment without just cause, in the violation of Title VII. So the plaintiff filed a complaint in district court alleging she had necessary qualifications for full-time employment, but she was not asked to come back. And then she was teaching before, and she was still not asked to come back, and she had no reoccurrence of problems or situations. So the plaintiff alleged she had been denied full-time employment and promotion based on sexual orientation because of violation of Title VII. Now, Title VII, you know, the college defense in both is Title VII does not apply to claims of sexual orientation discrimination, only race, gender, religion, age, and disability. Therefore, Hadley has made a claim for which there is no legal remedy, so she did not win the motion to dismiss this case. But to avoid and alleviate this issue, you know, you have to prevent specific issues of employer with no knowledge of Title VII. You know, making decisions of hiring, promotion, retention solely based on qualifications of the job cannot reflect discriminatory practices or failing to refuse to hire, discharge an individual by individual's race, color, religion, sexual, and national origin. So you got to have kind of an equal opportunity effect on person status. Therefore, you give them the option and opportunity. Now, Purdue versus Cooney, which was Molly Purdue. She was a former basketball coach and women's sports administrator at Brooklyn College. She brought suit, you know, alleging violations of Equal Pay Act, the EPA, under the Title VII of the Civil Rights Act of 1964, because the plaintiff alleged the defendants discriminated against her on the basis of her gender during the employment. The complaint was dismissed in its totality to the individual named defendants. However, the law claims that Cooney was dismissed. However, the jury returned a verdict in favor of Purdue because of the Equal Pay Act on her intentional discrimination claim. However, the court rejected Purdue's remaining claims, but the jury awarded Purdue the compensatory damages for intentional discrimination, and the parties agreed to court that she determined back pay. So, yeah, she might have lost the case on, on the Title VII and actually discrimination, but she did win on, the court did rule in her favor the Equal Pay Act, because everyone must be paid equal. It shouldn't be men higher, women lower. The EPA prohibits discrimination based on slowing wages between employees or based on sex for equal work on employment that require the same skill, effort, and responsibility under the equality of similar working conditions. So the judgment was entered in favor of Purdue against Cooney and Brooklyn College. Now, to avoid this employment issue, to alleviate issues, it's always equal, because the difference in salary between men and women are important key to avoid such cases. There is no gender equity laws mandating equality of opportunity for women. So employment issues regarding female and male-dominated jobs, there's no existing laws, rules, or regulations that have not been effectively used to help the equality for women and men-dominated careers. Certain specific ways to prevent and deal with these issues: to hire equally, pay equally, and give equal opportunities given the facility that you're working in, to avoid actions brought by employees, employers, coaches, student instructors, clients, and anyone working in the facility. Now, the application of faith integration. So if I was a director of a specific facility within the career as a collegiate coach or instructor, become a director of facility, you must identify specific issues and keys learned in the past 6 weeks that would help with legal management with the chosen facility. You have to look and understand risk management laws to ensure the safety of student athletes, which makes sure safe. These applications, such as like emergency and action plan, a crisis management plan, acknowledgement of sports safety measures that should be implemented for individuals with disabilities. Also, you must have equipment and a facility upkeep for safety and well-being of your student athletes, or your clients. Another actual application that you must know is the knowledge of Civil Rights Act, equality and equity in the facility. When you're a manager, you got to know Title VII and Civil Rights Act, how that works, the equality, no discriminatory actions, or even a hint if it seems that way. You just got to protect yourself and the organization and the facility you're working in. You must know Equal Employment Opportunity Commission, which monitors Title VII for the hiring purposes. You have to know and understand that if they have the right qualifications, they're entitled to an interview. They're entitled to equal opportunity to see if they're upkeep for the position. And then Title IX, no exclusion or down participation subject to discrimination under educational programming for functional assistance based sex and minorities. So if you're a Title IX, if you have a class, everyone has subjected to participation. Everyone has an equal opportunity to play the sport or have opportunity to try out for the sport. Now, the religious issues of being a collegiate coach and spreading the word of God is that there are certain instances where a coach could face legal issues for using God's word to guide their career by understanding the First Amendment. The major elements of the First Amendment often apply to the sport that include religious issues, predominantly public school based on prayer, freedom of expression, as the association had referred to as the Establishment Clause, and the Free Exercise Clause, which deals with religious freedom. The clause bans the government or its agencies from establishing state-sponsored religion, promoting or endorsing and aiding specific religion, favoring one religion over another by governmental concept. As is called this separation of church and state, by interfering with individuals' religious beliefs or practices. So myself being a coach, working with certain districts or this main district they're working for, that is a really big issue. And you can't impede or you can't pull over someone else's religious beliefs. But it's just one of those really iffy issues that you just have to be really aware of and concentrate you don't step over those boundaries. Now, my biblical references that I was looking at, I mean, I chose more than three because I feel like three. I feel like there wasn't enough, but I'll just name three. So I'll start with Matthew 7:12. So whatever you wish that others would do to you, do also to them, for this is the law and the prophets. Matthew 7:12 pretty much explains is you got to treat everyone evenly, you got to treat equally. And reading this, it explains how if you treat everyone the same, they treat you the same with the same laws, same principles, that together for you'll reach the ultimate goal, and that's for success. The other one that I chose was Galatians 3:28. There's neither Jew nor Greek, there's neither slave nor free. There is no male and female, for you are all one in Christ in Jesus Christ, or Christ Jesus. Uh, the same thing applies here when you're in the hiring process. There is no here, there is no this, that. There's no discrimination in trying to hire someone or work with somebody. That is what I get it from, especially like a human resource uh, plan there. And then I would think I'm going to go with the Colossians 4:1. Masters, treat your bondservants just fairly, knowing that you have also another master in heaven. Now, if you're a manager overseeing your people working under you, you're observing them, you're treating them fairly, you're treating them right. Therefore, I've known that if you treat your student athletes or your my head coach, my assistant coaches, you treat them in a fairly and respectful way, the return is great. Because there's only one master in heaven, and that's Jesus Christ. So there's not to think that I'm above everyone as being the spiritual coach. And I think that that's going to conclude my critical assignment. These are references, and thank you very much. I think I went a little bit over time, but I just love talking about the legalities working still as a collegiate coaching instructor. Thank you very much for viewing, and I'll see you guys soon.